And okay, so welcome back to continuation of discussion of consequences of incorporation. We were talking, raise up your hand, then I will call you. We're talking about the capacity to contract, and the line went off. So I think that is where we are. I think somebody has something in the chat. Yeah, where is it necessary to leave the corporate? Yeah, and that's, yeah, I heard you having a discussion. We have it as a topic on its own after this. So we are looking at the consequences of incorporation, and then we look at the lifting the or piercing the corporate veil. So we come and discuss that. Any other? Is there any other hand up? No hand up. Okay. Yeah, so we made the point that even there's nothing wrong for the company to even have a contract with its own members, as happened in the case of a lay and lease air farming limited. Very interesting case. The company employed one Mr. Lee, who owned nearly 3,000. Like he owned 2,999. The company had a total of 3,000 shares. So apart from one share, Mr. Lee was the holder of all the other shares. And Mr. Lee was also the only director of the company. And he has also been appointed a governing director for life. So MD for life, if you like. Now, Mr. Lee, unfortunately, was killed in the course of his work for the company. And the company's insurers alleged that there was no contract for service, so that no claim could be made under legislation, which made employers liable to pay compensation for accidental personal injury suffered by their employers at work. Yeah, see, when the man died and his wife sought to get compensation, what do you call like the workman compensation for the deceased husband who has died in the course of working for the company. An issue came up, and that issue was actually sponsored by the insurance company, saying that the deceased worker could not be paid the compensation because, in their view, he was the very person who signed the contract for the company, and he could not have actually entered into a contract for a company and for himself at the same time. Now, to that argument, Lord Morris of Baldaggers made the point that, quote, in their lordship's view, it is a logical consequence of the decision in Solomon and A. Solomon and Co. Limited that one person may function in dual capacities. There is no reason, therefore, to deny the possibility of a contractual relationship being created as between the deceased and the husband. So, therefore, the court rejected the insurance argument that Mr. Lee, being nearly the sole shareholder and the director and all that, could not one and the same time enter into personal contract with the company in which he was the majority shareholder and also the director. And so that reinforces the point that the company has capacity to contract, and being a separate legal person, it can even contract with its own members and its directors, as it were. So let us keep that in mind. And again, the obligations that may be associated with such contract are enforceable against the company as a person at law and not the shareholders. In other words, if there are contractual duties, contractual obligations, and they are to be enforced against the company, it is the company and the company alone that to enforce it against it and not against its shareholders. And the position is the same, even if the company is made up of a sole shareholder and a director who wholly controls affairs of the company, as happened in Lee against the Lee's Air Farming Limited. And that will be the case. The only exception being that maybe where you have appropriate circumstances which justify or warrant lifting the corporate veil, then that can be done. So let us keep that in mind. And on this, I have, I think they've taken the light and it's going to affect my internet. But I'm using a router. What do you call a turbonet? So sorry, so let me switch off the video. They've taken the light. Yeah, they've restored the light, sorry. Yeah, so I was going to tell you a practical example of this particular point we're discussing, and that has to do with the what do you call the veneer, Ghana, plywood and veneer company, if you remember. And we did a case against that company on behalf of a US client. I think they have supplied things with, and we got the judgment for almost $200,000. Now, we had to enforce the judgment against the company. And I realized that the company had become more or less a moribund in the sense that it was not functioning. So we decided to dig to find out. And we got to know that the Forestry Commission is a 100% shareholder. Now we know the Forestry Commission has got a lot of assets, monies and all that. So one will have said that then you can enforce the judgment against the Forestry Commission as the sole shareholder of Ghana Plywood and Veneer Company. But because of company law doctrine, because of Salomon and Solomon, because of Lee against Lee's Air Farming Limited, Moko and Kuma and all that, we couldn't do that because the company is separate. And if you have a claim against the company in respect of a contract, you enforce it against the company, not against the shareholders. So let us keep that in mind. Okay, so another consequence, consequence upon, okay, Dauda, please go ahead. Dauda, yes, you can ask your question.
Hello, sir.
Go ahead.
Say, I don't know if I have heard you right. As you said, if an action is taken against a company, you have to execute against the company is personally. What of there are instances where individual form companies and hide behind them to do fraudulent acts. So if you take a civil action against a company, which later on you realize that it's a fraudulent act, can't you leave the veil of incorporation to hold them personally liable?
Yeah, so good. I think you have the answer within your question. You have the answer within your own question. So as you rightly pointed out that if people are using the company to do bad things or evil things and all that, can't you actually ignore the corporate veil so that you reach out for those individuals? Yes, under appropriate circumstances, that is there. And I told you not long ago that we'll be discussing lifting the corporate veil. And for example, where people are trying to evade obligation or they are trying to conceal using the corporate veil, then the law will permit that the veil is lifted so that we can reach out and hold specific persons responsible for specific malfeasance rather than they hiding behind the cloak of legal personality. So that is right. Now, since the company is an artificial person at law, Lord Cranworth, in the case of Aberdeen Railways against Blackie Brothers, later when we are discussing directors, we come across it to make the point that the company does not have a leg and hand of its own. It has to function through the instrumentality or through the agency of flesh and blood, human beings. So the company acts through its officers, members, and agents. So if you look at section 144, can somebody read section 144 for us? 144 of Act 992. Section 144, can you take it for us?
Okay, so I'm reading.
Good.
Division of powers between general meeting and board of directors. A company shall act through the members of the company in general meeting or the board of directors or through officers or agents appointed by or under authority derived from the members in general meeting or the board of directors.
Okay, good.
2, subject to this act,
yeah, it's even okay for the time being. Good. Now, so if we take section 1441, it's telling us about how the company, for example, acts. Despite the fact that it is an artificial legal person, it functions through human beings. So it acts through its members. The members are human beings, more or less, as shareholders. Of course, I also appreciate that you can have artificial persons as members, because the company can also be a member of another company. Just as I told you, Forestry Commission, which is a corporate body, was the sole shareholder of the Ghana Plywood and Veneer Company. So that is possible. Then it also acts through its directors. Directors are always human beings. And also its other officers like employees and so on. And that is why, if you take the case of Moko and Kuma again, the supplier of the fish sought to do was to say that because the chief executive of the company, which was giving fish on credit basis, had actually signed for the company, it could also be made liable for the debt. And the court said no, that the chief executive officer was only acting for the company. So the company acts through human beings. So you look at section 1441 and also the case of a Morocco and Kuma. And of course, if we take the old case of like the Royal British Bank against the Tekwan, a similar point was also made. I think that somebody's hand was up. Dauda, your hand is up. Yes, Dauda. Is your hand up?
So it's a mistake. He's struggling with his connections.
Oh, right. Okay, so let's say in the next 15 minutes, we will end the class so that, when is our next class? What time is our next class?
So that's very good. The next class 12 p.m. and we are all at home.
Oh, okay. So if we end in about
Yeah, we'll start moving.
okay, that is fine. Okay. Yeah, so another consequence, and this is quite pertinent, and you should remember. Another consequence of incorporation, or the effect of the company becoming unincorporated, is that the members have limited liability, especially so where the company is a limited liability company. And again, the company has property which is separate from that of the members. So members are not liable for the debts and liabilities of the company. If the company owes something, it is the company's own debt. It's not the debt of the members. And Moko and Kuma made that point. So let's notice that Salmon and Solomon himself has made that point. And the liability of members of the company is limited. In the case of company, limited by shares and by guarantee. So as we have noted, where it is company limited by shares, then as a shareholder, in case the company, for example, becomes insolvent and all that you stand to lose is the money that you have paid for your shares. That is what you stand to lose. After not getting that money back, if the company is still owing others and it does not have money to pay them, nobody can call upon you to bring more money to clear those debts of the company. So let's keep that in mind. Again, if you're a shareholder and you have not finished paying for the shares which were issued to you, then you could be called upon to come and pay the unpaid debt. That is the unpaid value in respect of your shares. Once you have paid that, if the company's assets are even not enough, nobody can call you to pay again. So let us keep that in mind. Of course, with the unlimited liability company, as we noted when we're discussing types of companies, as the name suggests, unlimited. So the liability of the members are not capped at all. So the company being incorporated has got nothing to do with the liability of the members. And if we look at section 7 of Act 992, we've discussed that already. It reinforces that unlimited liability company, there's no limit on liability of its members. So let us keep that in mind. Again, the company being a separate legal person has the capacity to acquire property. And the property that the company acquires is the asset of the company, which is quite separate and distinct from that which is held by its members or officers. So therefore, property of the company is not property of its members. Somebody has put something. So if you look at the case of a shots against Treasury commissioners, for example, the point was made that shareholders are not, in the eye of the law, part owners of the undertaking. The undertaking is something different from the totality of the shareholding. And this principle runs through every facet of company law. Things which belong to the company and not members. It doesn't matter. You see, later on, as you make more progress in your legal education, become lawyers and all that. When you are making a will for a person, okay, if the person is even the 100% owner of shares in the company, you will never go out of your way and say that I have willed my company, SYZ Limited, to Mr. B. That is legally incongruous. It is conceptually flawed because according to orthodoxy, according to the principle in Solomon and Solomon, the company is separate. And for that matter, like cases like Makora and Northern Assurance and all that tells us the company's assets or the company's properties are different from that of its members. So what you rather do is to will the shares that you have in the company. Or if you want to give a gift, you give a gift of your shares and not the company itself. Because if you say you are giving like the company itself, you'll be doing violence to elementary principles of company law. So if you take the case of Macaulay against the Northern Assurance, for example, reported in 1925, AC 619, the owner of a timber estate sold all the timber to a company in which he owned almost all the shares. So he owned all the shares in the company that he sold the property to. He was also the company's largest creditor. He insured the timber against fire by policies taken out in his own name. So the insurance was in respect of the property the company owns, but the insurance policy was in his personal name. Now, unfortunately, the timber was destroyed by fire, and he sued the insurance company to get compensation. The House of Laws held that in order to have an insurable interest in a property, a person must have legal or equitable interest in the property and not merely a moral certainty of profiting or losing from the property. In other words, the court was saying that if you look at the circumstances of Macaulay, Macaulay and then his company, despite the fact that the insurer was the ultimate beneficiary of any profit or sufferer of any loss and so on, the court was saying that to have an insurable interest, you must be the legal owner or have like the equitable, if you like, the title, as it were. And in the circumstances of this case, talking about the property, it belonged to the company and did not belong to the man. So, and for that matter, the case against the insurance by Makora failed. He was not successful because the policy that he took, the policy was in his name, meaning that he was supposed to have the insurable interest. The property which he insured did not belong to him. The property belonged to the company. And for that matter, you could not actually properly enforce that insurance policy in respect of that property, which did not belong to Mr. Makora and rather belongs to the company. And for that matter, in the course of that case, Makora against Northern Assurance. Lord Renberry made the point, and I quote, "My lords, this appeal may be disposed of by saying that the corporator, even if he holds all the shares, is not the corporation, and that neither he nor any creditor of the company has any property, legal or equitable, in the assets of the corporation," unquote. So simply put, the court was making the point that the property of the company which got bent, in respect of which he purported to have taken insurance, did not belong to him. So he did not have insurable interest. And since you don't have insurable interest, you cannot actually insure it against any risk or fire. Another legal consequence or legal effect of incorporation is that the company has the capacity to sue and be sued. The company has the capacity to sue and be sued. If the company has suffered wrongdoing, it is the company which will fight its own fight and not any person fighting for it. And a plethora of authorities have actually confirmed that a company upon incorporation has capacity to sue to enforce its claims owed to it in its own names. So in our own Ghana here, the case of Bank of West Africa against Apenten, and also the very well-known case, what they call the Force and Habertel. And Force and Habertel, the courts established two important principles, which we will discuss again when we are talking about the majority rule and protection of minority as a topic in the second semester. In Force and Habertel, the court established what they call the proper plaintiff rule, and also the majority principle. And essentially, the court stated that where a wrong is done to a company, it must sue in its own right and capacity. So if the company has suffered a wrong, if somebody has done something wrong against the company, if you're a member of the company, originally, according to Force and Habertel, you are not the one to take up the case for the company. The company has to take up its own case because it has a legal persona. It can sue and be sued. And for that matter, if you look at section 200, subsection 2, the company can only litigate if it has in its own right, like it acting in its own right, probably through the board of directors, or people are authorized to embark on proceedings. So if you go to later on when we are discussing what they call the derivative actions and so on, we also talk about situations where people can take up cases on behalf of the company if those who are supposed to, for example, take it up are not taking it up. The registrar of companies, for example, can decide to take up cases on behalf of the company at the end of investigation into the affairs of the company. But we come and discuss this in much more detail later on when we are discussing those topics. But at this stage, all that we are trying to demonstrate is that the company can sue in its own rights and can also be sued in its own right. So if you wanted example, yeah, SP.
Yes, sir.
Yeah, go ahead.
So, with regards to the company having the capacity to sue and can also be sued, in this instance, it means that it is not only external companies or persons that the company can sue, but it can also sue its members as much as its members can also sue it.
Yes, absolutely. So there is a, we'll be discussing what we call the constitution of the company. And then when we discuss constitution of the company, we discuss the effect of the registered constitution. And we come across the constitution is a contract under seal between the members, the companies, and so on and so forth. So yes, it is possible for the company to sue its member. And it's also possible for a member to sue the company, quite apart from external entities. Yeah, so that is right. So we wanted to give example of how the company, for example, can be sued. And typically when we are discussing issues of oppression or remedy against oppression, maybe somebody, a minority, saying that the way a manner affairs of the company are being run are in disregard of his proper interest as a member, prejudicial to his interest as a member, and so on. The law under section 218 and 219 permits such an aggrieved person to sue the company as it were. Another legal consequence of incorporation is that the company acquires perpetual succession. Upon being incorporated, the company acquires perpetual succession. And of course, it can also raise capital, especially where it is not forbidden. Now, being a separate legal person means that the existence of the company is not coterminous with the life of the members. In other words, the company does not need the members to remain alive for it to exist, as it were, especially its legal existence. And for that matter, if you look at section 41, section 41, so somebody take section 41 for us. 41. Can we look at section 41? Okay, the reader is gone. Okay, so if you take section 41, if at any time a company ceases to have a member and it carries on business.
Section 41.
Yes.
Companies ceasing to have members. I'm reading, sir.
Okay.
If at any time a company ceases to have a member and it carries on business without at least one member, every person who is a director of the company during the time that it so carries on business is jointly and severally liable for the payment of all the debts and liabilities of the company incurred during that period.
Okay. Yeah, so yes, section 41 is talking about where the company does not have a member at all and is still running business. Now, the fact that the company does not have a member does not really relate to its legal existence. So it does not detract from the point being made that upon being incorporated, the company has perpetual succession, so to speak. Yes, the company can cease to have a member. And when it ceases to have a member, then the law does not want people to use the company to do unacceptable things and all that to the detriment of the well-being of the company. And that is why section 41 is trying to say that if the company does not have a member and you are so pretending over the company, actually running a business, then if liabilities are incurred, you are going to bear personal liability rather than the company. Again, apart from perpetual succession, another consequence of incorporation is ability to raise capital by borrowing, maybe through creation of debentures. A company can create debentures. That debenture simply means a long-term or permanent loan, evidence in writing. And the company can use some of its assets as a security to assure creditors that it will be able to pay back the money which it is borrowing from them. And again, if the company is a public company, it may also make invitation to the public for the purchase of its shares and other securities. And all this will enable it to capitalize, to raise money. Now, this has been made possible because it is incorporated. So if it has not been incorporated, it couldn't have actually take advantage of the legal facility, which says that you can make invitation to the public. Another consequence of incorporation is transferability of interest and also separate management. Transferability of interest and separate management. And although we come and discuss issues like capital maintenance, corporate governance, and all that, at this stage, it suffices to note that a company has no obligation to buy back its shares, which have already been sold. I noticed you have another class, so I'll end here. We continue Monday going. All right. So I'll send the materials also to you.